the first to know. Nsem-Pii TV.
Supreme Court are there. Supreme Court are there. In fact, the learned Attorney General Godfrey Yeboah is advancing his argument with respect to a decision that needs to be made by the Supreme Court on the declaration of some 4 seats vacant by the Speaker Alban Samana Kingsford Bagbin. Now, this particular issue, I travel for some time now. Supreme Court do 2 different rulings now. In fact, Alban SK Bagbin asked the Speaker of Parliament in Nigeria or the Ebeye Juma. And the Supreme Court deliver the verdict and casa as to say the declaration of those 4 seats vacant is it constitutional and a constitutional. Now, said the Michelle Senamekana, the learned Godfrey Yeboah is advancing his argument. Now, Penny Kohe, the Awadiye lawyer Tadio Sorry and other lawyers representing the National Democratic Congress, it was Supreme Court in Primpri and Menimokase. In fact, any can. Now, it clearly shows that Obinya Brisuambrano, Obinsu Eate based on emotions and precedenta. Nasa precedent no krano. Enyina emraso. The learned Godfrey Yeboah echo 2 different articles from the Constitution to, in fact, make his argument relevant in the court of law. Now, where the Supreme Court bench and the 4 judges and the 4 and then judges and so led by the Chief Justice herself, Justice Gertrude Tukono. Very, very interesting times ahead. Now, I said the eventually the National Democratic Congress will come out and call them unanimous FC if the ruling goes against them that every step taken by Alban Sumana Kingsford Bagbin was duly against the strict interpretations of various articles in the 1992 Constitution. So therefore, Yenzomu straight to the highest decision-making body in terms of interpretation of the Constitution, that is the Supreme Court. Now, you're enjoying the live feed. Now, you're quite the learned Attorney General Godfrey Yeboah advancing the argument on this vacant seat brouhaha.
The constitution of the country has been unlawfully upset. And the second point I make respectfully is that everything in the Constitution, from the regulations affecting the performance of the Electoral Commission's functions, in Chapter 7, up to the composition of Parliament, or the entire chapter on the legislature. The entire chapter on the legislature in Chapter 10 shows that Parliament, when used, refers to a specific term.
Hold on, the word Parliament.
The word Parliament. Parliament, when used, refers to only one term of Parliament in session and nothing more. And that when the people of Ghana respectfully also elect a member of Parliament, when the people of Ghana vote in the election of members of Parliament, that election is for only one term. And they do not have in mind the election of members of Parliament beyond the term of Parliament for which they voted. Well, I refer to Article 113. Article 113 clause 113 clause 1 of the Constitution. And it says quickly, subject to clause 2 of this article, Parliament shall continue for 4 years from the date of its sitting, and shall then stand dissolved. Clause 2, respectfully, provides that at any time when Ghana is actually engaged in war, Parliament may from time to time, by resolution supported by the votes of not less than 2/3 of all members of Parliament, extend a period of 4 years, specified in clause 1 of this article, for not more than 12 months, except that the life of Parliament shall not be extended. So clearly, Parliament is for only 4 years and nothing more. My lady, this is further reinforced by...
Excuse me. Can you turn to page 24 of your statement of case, please? 23 and 24.
Oh, page 23.
Paragraph 32 and paragraph 33.
Yes.
Is what you are saying there?
Yes, Mr. But I will further, and they don't allude to clause 2 of Article 97, which I'm coming to. Especially, clause 2 of Article 97 is very important. And so the point I make from all of this is that anything that affects the composition of Parliament for a future Parliament which has not yet been elected is unknown to the Constitution. The Constitution does not anticipate that all the matters set out in Article 97 clause 1, including J and H, which are an issue before the court today, have any bearing on matters beyond the life of a current Parliament. They have only consequences insofar as the current Parliament is concerned with. Respectfully, apart from the clear or the indication in the language of Article 97 clause J, which talks about a person seeking to remain in Parliament, I will refer the court to Article 97 clause 2, which has not featured so far in the argument for the court. Article 97 clause 2 is in these terms: notwithstanding paragraph G of clause 1 of this article, a merger of parties at the national level sanctioned by the party's constitutions or membership of a coalition government of which his original party forms part shall not affect the status of any member of Parliament. So the point being sought to be made from Article 97 clause 2 is that even a merger of political parties in the life of any Parliament has no effect whatsoever on the status of a member of Parliament. Thus, if today the NDC and CPP, respectively, come together, okay, because I don't want to say, okay, sound right. So I would prefer a merger between the NPP and CPP, as occurred in 1996. So, respectfully, indeed, the implication is that if in the first Parliament of Ghana, the NPP had elected to contest parliamentary elections, which we all know from history that they did not, and in the course of the life of that Parliament, as actually occurred, a merger between CPP and NPP occurred, the status of a member of Parliament standing the ticket of MPP as an MPP MP shall not be touched, shall not be affected by the Constitution. So if indeed MPP and CPP had come by an arrangement, as they did actually in 1996, that for the Nsem-Pii constituency, the MPP will not contest, and the CPP rather will contest, which indeed was the case. But the MPP at that time already had a sitting member of Parliament in the Nsem-Pii constituency, and by virtue of that had more or less ceded his interest or right to a CPP member. Respectively, that would not necessarily result in a vacation of the seat of the member of Parliament. So if indeed on account of clause 2 of Article 97, it has been decided that for constituencies already held by the MPP, for the purpose of the upcoming election, those candidates or those members of Parliament shall contest on a ticket of CPP or a different political party. Article 97 clause 2 suggests clearly that the status of such members of parliament as MPs shall not be altered. So especially this, in my respectful view, fortifies the proposition we make that any decision by a member of parliament to change his political identity for an upcoming election shall not necessarily result in a vacation of that member of parliament seat. I don't know if I'm making myself job. I'm moving. So, right. Especially apart from that, I'll refer the court to Article 47, Clause 5 of the Constitution, which is also a further indication. 47, Clauses 5 and 6 of the Constitution, which talks about alteration of the borders or boundaries of constituencies. So the point is that the Constitution, as I indicated, anticipates that the change in the composition of Parliament or the change in an anticipated composition of Parliament in the future shall have no effect presently. And that's supported by Article 47, Clause 5, which vests the Electoral Commission with the power to review the divisions of Ghana into constituencies at intervals of not less than 7 years, especially as we stand before the court. Indeed, the number of constituencies for the upcoming 2024 elections has been altered by the Electoral Commission. Rather than 275 constituencies, we will have 276 constituencies in the December 2024 elections because of the alteration of the boundaries of the Boem constituency, with the result that there has been the creation of a new constituency for what we call the South people, the Santo Kofi, Lolobi, and Akpafu area. Clearly, the alteration of the boundaries of the existing Boem constituency now has not affected the status of a member of parliament sitting as MP in the Boem constituency. That alteration only has effect in the December 2024 elections. So the point I'm making with respect is that it is so clear from the Constitution that whenever a member of parliament decides to change his political identity, or indeed the Constitution itself seeks to enforce a change in the composition of parliament for the next election, it has no effect in the current term. If that were the case, presently the South people would vote now and elect their MP, but they cannot vote now and elect their MP. They must wait until December 2024. I'll quickly wrap up with a swift address of issue 3, which is whether or not the declaration by the Speaker of Parliament of 4 vacancies.
I have a question.
Right.
And my question is, what is the point of the provision in Article 97(1)(g)(h)? Why did the framers of the Constitution put them there?
Right. Right.
I know you have addressed it in your, if you don't mind. I know you have addressed it in your submissions, but I think that by reason of the last point made regarding Article 47(5), we need to have some light shed on
it. So the purport of Article 97(1) and G is to prevent situations where a person in the life of a current parliament seeks to alter his political identity. That is frowned upon by the Constitution. So that if a person comes to parliament or having been elected as a member of parliament for a specific term as an MPP candidate or whatever political party candidate, in the course of the term of that parliament wishes to move to a different political party, the Constitution says that is prohibited. If the person also seeks to continue, and that is indicated by the use of the word seeks to remain in parliament, if the person seeks to continue his tenure as an MP during that term of parliament as an independent candidate, that is prohibited by the Constitution. Am I ready? Indeed, such situations have occurred in this country. It is not without history or antecedent. So clearly, the Constitution anticipated a change of one's political identity within the term of the current parliament, and not an anticipation.
Mr. Dami, can you give us one or two instances where
such, okay,
exactly historical antecedents?
Right. Especially in the first parliament of Ghana, there were about 3 or 4 instances whereby my Lord, in the first parliament, there were 3 or 4, no, the first parliament, 1960, under the 1960 constitution, there were 4 instances in which some members of parliament crossed carpet or changed their political identity. There were the cases of J.A. Brima, Mumuni Baumia, Tampuri, and the Tolona. They crossed carpet from the then governing CPP to join a different political party. Others also crossed carpet from the opposition party to the governing CPP. In view of that, the court would note that the 1960 Constitution had no such provisions at all. In view of that, for the very first time in 1969, a provision to that effect was enacted. And I refer the court to Article 75, Clause 2, Paragraph G of the 1969 Constitution. In the Assembly, upon the resolution of the National Assembly, a member of the National Assembly shall vacate his seat in the Assembly if J. he leaves the party of which was a member at the time of his election to the National Assembly to join another party. This was the first time, the Second Republic, that a provision like that was introduced. The provision again was repeated in 1979 Constitution, and it was at Article 79. Article 79, Paragraph I of the 1979 Constitution. It says, a member of Parliament shall vacate his seat in Parliament in if he leaves the party of which he was a member at the time of his election to join Parliament, to join another party. At the time of his election, to join another party. So that's it. Then the provision was repeated in 1982. It's like when the 1982, a situation like that occurred, and I refer the court to the circumstance of Alhaji Wayo Seni, Professor Wayo Seni, who crossed carpet from the party on the ticket of which he had been elected as member of Parliament to join another political party. At that time, the Speaker of Parliament indeed rightly ruled that he had vacated his seat. Especially this situation that we find ourselves in before the court had again occurred in Parliament, in the 7th Parliament. The Speaker of Parliament, just like the current Speaker, ruled that he had no vacation of seat. My respectful submission on that point is that such ruling was erroneous. The ruling that affected the status of Honorable Nsem-Pii, my lady, I love because the gentleman suffered a lot. The last Parliament, he was declared to have been to have vacated his seat. This Parliament again, too, his seat has been vacated. One person. He suffered a lot. So, my lady, and my point is that no matter the number of times an unconstitutional act is repeated, it has not ripened into constitutionality. This court has said in numerous cases.
So you're wrong.
Yes, this court has said in numerous cases. It started from Tifo and Atejara up to the recent matter, an ex parte charge or so. Yes, ex parte charge. 2007-2008, Supreme Court of Ghana report, Volume 1, at page 213. that an unconstitutional act, no matter the times repeated, respectively, does not ripen into constitutionality. So the fact that the previous speaker had ruled that Mr. Nsem-Pii had vacated the seat, and that is being sought to be used as a precedent today, does not mean that it's constitutional. Especially, I'll be done on this case.
You had only 3 issues.
Yes.